Is that this bill be now read a second time. The member for Flynn.
Thank you, Deputy Speaker. I rise to speak on the constitutional alteration of the Aboriginal and Torres Strait Islander Voice Bill 2023. The proposed law that Australians are being asked to approve at the referendum would insert a new section into the Constitution. The proposed constitutional provisions would read, "There shall be a body called the Aboriginal and Torres Strait Islander Voice. The Aboriginal and Torres Strait Islander Voice may make representations to Parliament and Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. The Parliament shall, subject to this Constitution, have the power to make laws with respect to the matters relating to Aboriginal and Torres Strait Islander Voice, including the compositions, functions, powers and procedures." So, there are questions related to the provisions or the proposed provisions. And in point 1, in relation to the first sentence, who will make up this body? How many will there be? Will they be elected or will they be appointed? How will you qualify to be of Aboriginal or Torres Strait Islander descent? How often will this body change to be elected or appointed? Will these people be paid? If so, how much? Will they have bureaucratic support? And if so, to what extent? How much will this cost? How often will this body meet and where will they meet? These lists of questions, Deputy Speaker, can go on and on. In point 2, in relation to the second sentence, everything, all matters relate to Aboriginal and Torres Strait Islander peoples. They are Australians. Nuclear submarines, the budget, mining approvals, interest rates, health, education, housing, the cost of living. It goes on and on. The Constitutional Expert Group has said, and I quote, "The Voice will have the right to speak on a vast array of agencies," and they named examples: Centrelink, the Great Barrier Reef, the Ombudsman, even the Reserve Bank. The executive includes every minister, department, public servant, independent statutory body and agency at a federal level, as well as the Northern Territory and Australian Capital Territory, as these government apparatuses exist under Commonwealth legislation and oversight. Therefore, the potential for the scope of the Voice is nearly limitless. In point 3, in relation to the third sentence, if the Australian people vote in favour of constitutional change in its current form, any parliament will be required to uphold the Constitution, and in my view, they cannot legislate to override the Constitution and have powers to make laws with respect to the composition, functions, powers and procedures of Aboriginal and Torres Strait Islander peoples in respect to point 2 of the constitutional proposal. Deputy Speaker, Australia's Constitution is our most important legal document. The Australian Constitution is the rule book for our governing and law-making institutions and Parliament, being open for participation to all Australians. It remains the best body to represent all Australians. To amend the Constitution to permanently alter the functioning and representative capacity of Parliament will undermine the universality of the Constitution itself, and any attempt to assign a new political or legal right to one group of people could make the Australian society less harmonious and permanently divided. Every word can be open to interpretation. Enshrining Labor's voice to the Constitution means it's open to legal challenge and interpretation by an unelected High Court of Australia. The Voice will open up a legal can of worms. Legal experts themselves do not agree. They are not sure on how any High Court will interpret such a constitutional change. Labor's proposed voice model isn't just to the Parliament, but to all areas of executive government. There is a risk of considerable delays to government decision-making. This risks dysfunctional government. As Ian Callaghan, former High Court judge, has said, I would foresee a decade or more of constitutional and administrative law litigation arising from the Voice. Canberra does not always know better than those who are on the ground, in particular in these regional and remote communities. Deputy Speaker, Australia hasn't changed its constitution by referendum since 1977. It's a big decision, but Labor refuses to reveal any details before the Australian people vote. They are asking Australians to vote without knowing exactly how the Voice will operate. Labor is putting the cart before the horse. The Voice is part of a three-stage process: the Voice, Treaty and Truth. Labor has conveniently not been upfront with Australians in relation to this. Some Voice activists say this will be the first step to reparations and other radical changes. Australians deserve all the details before they vote on a permanent change to our Constitution. The Voice is also divisive. The big danger with the proposed constitutional amendment is the destruction of equal citizenship. As Senator Jacinta Price says, we are one together, not two divided. Enshrining in our Constitution a body only for one group of Australians means permanently dividing Australians by race. Many Indigenous Australians do not want this split. We need to bring Australians together and not divide them, as Mr Albanese wants to. The Voice will be a permanent, publicly funded group for Aboriginal and Torres Strait Islanders, which has an additional rights that are embedded in our Constitution. Those rights will be procedural rights to make representations to Parliament and the Executive Government in relation to absolutely everything. At its core, the Voice is divisive. This will divide our country along the lines of race and do nothing to help our most marginalised members of our Indigenous communities. The Voice will forever be a symbol of division rather than an instrument of unity. It says to some of the most marginalised Australians that you are different from everybody else. You will be treated differently forevermore. This top-down, elitist Canberra Voice does nothing to help Indigenous communities on the ground who want to build better lives for themselves and their families. We all want better outcomes for those most marginalised people in our communities. In our national anthem, we proudly say, "We are one and free." What the Albanese government is proposing with this Voice is a way of dividing us. That certainly does not make us one. We should be one together, not two divided. The simple proposition of whether we are willing to divide our country along the lines of race is something we should all examine very closely. The Coalition does not believe that is what Australians want. Deputy Speaker, we will be changing the rule book forever. Once the Voice is in the Constitution, it won't be undone. Once a High Court makes an interpretation, Parliament cannot overrule it. We'll be stuck with possibly negative consequences and bad outcomes, and this does not help our Indigenous peoples. In 2023-24, the government allocated $4.3 billion for the National Australian Agency, which has over 1,400 staff. Their role is to advise government on improving the lives of Indigenous Australians. Labor's Voice would basically replicate this, and it is not clear how the two would interact. Mr Albanese has forgotten to tell the Australian people that this Voice is the first step in a three-part process: the Voice, Treaty and Truth. Mr Albanese should be upfront with the Australian people.
I remind the member to use the correct titles of members in this place.
Mr Albanese, our Prime Minister, should be upfront with this.
I'll ask the member to use the title of the member.
The Prime Minister should be upfront with the Australian people. This is not the end of the process. This is the beginning of the process. The Australian people should be asking, well, how much is that going to cost us in the end? We should get some indications of how much it is going to cost just at a state level. You've only got the treaty deals and Queensland Government is considering. They are talking about hundreds of millions of dollars. This is a modest change and we don't know how the Voice will work. The Prime Minister asking Australians to vote for this huge change in our Constitution without giving them the details on how it will all work. Many who advocate for the Yes campaign are trying to portray this is no big deal and something that we should be just waved through on the vibe. It is a very big deal and that will change our country and the way we are governed forever should the referendum concede. You should not change the rule book or change Australia. In this case, not for the better. There is nothing modest trying to change and pass this off us as something of a national changing rule book. We have no firm details on how Labor's Canberra voice will work, but we do know that it will be able to reach into all levels of government, including the executive, which means all government departments. The government refuses to tell us how much this voice will cost, how many extra public services will be required to service the voice. What is the anticipated recurrent expenditure? How much will the taxpayer spend on motor vehicle fleets, accommodation, travel expenditure? A proposed voice in this form would be a danger to government decision-making. The big danger in the Albanese government Canberra voice is that the administration and decision-making of government departments will be wrapped up in another layer of complexity and no doubt be slowed down by this process. Deputy Speaker, does anyone really want another layer of bureaucracy in their life? We all know that bureaucracy is incredibly slow. Importantly, one of the great unknowns is what will happen in advance of Parliament and government departments making decisions that may affect Indigenous Australians. Eminent lawyers and judges just simply cannot agree. If the voice is given constitutional functional making of representations, many say it will have to be told in advance relevant matters that are being acted on or decided by government. The voice would then have to be given the time and resources to analyse these matters to decide whether they will put forward a position. If that is not done, its constitutional rights will have been breached, opening government up to constitutional and administrative law litigation. So how would any government operate effectively with such handcuffs? This potential administrative paralysis will happen across all government departments with other arms of government. Parliament could never limit or define the matters on which the voice could make representations or the agencies to which could make them. The Prime Minister is on the public record, and I quote, "It would be a very brave government who ignored the representation put forward by the voice." He is admitting to defy the voice will trigger a legal challenge. And make no mistake, if there is constitutional change in its current form, democracy will change to the detriment of all Australians. The assigning of new political or legal rights to one group of Australians based on race will permanently divide us as a nation. My position remains no, as there is no substantial or detailed explanation on the working scopes and limits of the voice or explanation as to how this will provide better outcomes for Aboriginal and Torres Strait Islander peoples in general. Deputy Speaker, many Australians would be prepared to recognise Aboriginal and Torres Strait Islander peoples as our first Australians in the Constitution. However, this referendum proposal is suggesting that we divide Australia based on race and give these people power to coerce any government to their will, over and above all other Australians. It is Orwellian in nature. All animals are equal, but some animals are more equal than others. And this is why this is dangerous and why it is wrong. The government has failed at every turn to explain the details and the workings of the voice to Parliament. They have not offered any substance as to how this will deliver better outcomes to our most marginalised Australians, and this is why I oppose this bill.
The question is that the bill be